Good morning. Today is August 12th, 2025. This is an adjudicatory hearing before the Massachusetts Gaming Commission relative to a request for a finding of durable suitability for Betfair Interactive US LLC doing business as FanDuel Sportsbook, which currently holds a temporary Category 3 tethered sports wagering operator license. I will refer to Betfair Interactive US LLC as FanDuel or the licensee. My name is Jordan Maynard, and I'm the chair of the commission. I'm joined here today by my colleagues, Commissioners Eileen O'Brien, Brad Hill, Nikisha Skinner, and Paul Broder. The entire commission will preside over the hearing and decision in this matter. This hearing will be conducted in accordance with 205 CMR 101.01, Massachusetts General Laws, Chapter 30A, Sections 10 and 11, and 801 CMR 1.02, the Informal Fair Hearing Rules. This hearing is being conducted via remote collaboration technology. Before we begin, I would like to explain the process that will govern this proceeding. First, a notice of hearing was provided to FanDuel in advance of today's hearing. Therein, it identified the issues that this hearing is intended to address. The Commission has indicated that it will specifically be considering the issues discussed in the notice, including the following. The durable suitability of FanDuel pursuant to 205 CMR 215.011 and the contents of the Investigation and Enforcement Bureau's suitability report. I will now turn to our Associate General Counsel, Judy Young, to explain the suitability standard that we will be considering during our discussion here today. Good morning, Counselor.
Good morning, Chair. Good morning, Commissioners. Thank you, parties, for being with us. The Commission has convened today's proceeding to consider a durable finding of suitability for Betfair Interactive US LLC doing business as FanDuel Sportsbook under 205 CMR 0.01 subsection 1. The Commission adopted subsection 215 of the regulations to govern suitability determinations. Section 215 includes provisions allowing for a durable finding of suitability, the so-called final determination, and it also included a provision relating to a preliminary finding. FanDuel currently holds a preliminary finding of suitability, which the Commission approved on January 19th, 2023. The Commission subsequently issued a temporary Category 3 sports wagering operator license to FanDuel on February 23rd, 2023. The finding of preliminary suitability was based on an evaluation of the criteria set forth in 205 CMR 215.01 subsection 2, 205 CMR 218.06 subsection 5F, and General Laws Chapter 23N, Section 6D. As a refresher, the suitability criteria in review today include the following factors: the overall reputation of the applicant, including but not limited to the integrity, honesty, good character, and reputation of the applicant/qualifier, the financial stability, integrity, and background of the applicant/qualifier, the business practices and business ability of the applicant to establish and maintain a successful sports wagering operation, whether the applicant or qualifier has a history of compliance with gaming or sports wagering licensing requirements in other jurisdictions, whether the applicant or qualifier at the time of application is a defendant in litigation, the suitability of all parties in interest to the license, including affiliates and close associates, and the financial resources of the applicant, whether the applicant or qualifier is ineligible to hold a license under 205 CMR 0.01 subsection 4, General Laws Chapter 23N, Section 9A, or Section 6E, whether the applicant or qualifier has been convicted of a crime of moral turpitude, whether and to what extent the applicant or qualifier has associated with members of organized crime or other persons of disreputable character, and the extent to which the applicant or qualifier has cooperated with the IEB during the review of the application. By the terms of 205 CMR 215 of our regulations, any finding of durable suitability must be supported by clear and convincing evidence, not just substantial evidence, which is a lower standard used for the remainder of licensing applications. Our jurisprudence tells us that clear and convincing proof exists when the evidence induces the mind of the fact finder a reasonable belief that the facts asserted are highly probably true, that the probability that they are true or exist is substantially greater than the probability that they are false or do not exist. For evidence to be clear and convincing, it must be sufficient to convey a high degree of probability that the proposition to be proved is true, and it must be strong and positive and full and clear and decisive. In the matter before you, you may choose to award a durable finding if you conclude that the applicant and each of its qualifiers has demonstrated their suitability by clear and convincing proof. Such a finding would be a positive determination under 205 CMR 215.01 paragraph E, and may include conditions and restrictions if applicable. If the commission determines that the evidentiary burden on suitability is not met, it would issue a negative finding or a negative determination with respect to suitability. And with that, I turn it back to you, Mr. Chair and Commissioners. Thank you.
Thank you, Councilor Young. We appreciate you walking us through that. I understand that FanDuel is represented by counsel here today. So at this time, I would ask for FanDuel to please identify yourselves and your team.
Good morning, Chair. Jed Nozel on behalf of FanDuel today.
Thank you. At the conclusion of my opening comments, this proceeding will commence with the IEB's presentation of its findings to the Commission pursuant to 205 CMR 215.01, subsection 1, and 205 CMR 115.03. Any commissioner may ask a question of anyone presenting information at any point during or following the presentation. At the conclusion of the IEB's presentation, FanDuel will be afforded the opportunity to ask questions of any individual who presented information on behalf of the IEB as well. At the conclusion of the IEB's presentation, the licensee will be given the same opportunity to make its own presentation. They may call any witness and present any other evidence they desire. As before, any commissioner may ask any question of any witness or presenter at any time during or after the presentation. FanDuel may raise any objection it desires at any time. However, the basis for such objections shall be clearly stated. After FanDuel's presentation, the Commission will address each topic area from the notice of hearing in turn, and each commissioner will have a full opportunity to ask questions of any witness concerning those topic areas before we move on. Finally, at the conclusion of the presentations of all the evidence, the licensee will be provided with an opportunity to make closing remarks, summing up its view on suitability. Before we begin, I understand that there are a number of exhibits that have been prepared and pre-marked in advance of this hearing. Those exhibits are identified on the exhibit list that each party has received. For each party, please confirm receipt of the exhibit list.
Chair, those were received.
Thank you, Jed. Councilor Kennedy?
Yes, the IB's received them.
I'll note for the record that the exhibit list will be marked as Exhibit 11 for this proceeding. Are there any objections to Exhibit 1 through 11 being marked and entered into evidence?
None on behalf of FanDuel.
No objection from the IEB.
Thank you both. These exhibits shall be admitted into evidence. For the purpose of ensuring a clean record, I ask that everyone, when possible, please refer to the aforementioned exhibits by exhibit number. Further, if anyone would like to have additional documents entered into evidence during the course of the hearing, please ensure that they are properly introduced and marked for the record. As explained, the Commission anticipates that its inquiry at this proceeding will be related to the matters addressed in the notice of hearing relative to the licensee's durable finding of suitability. In the event that a line of questioning conducted by the Commission moves into an area that has not been included in the reporter notice, but is material to the final determination of the matter, any party may request a recess in the proceeding in order to review the issue. The Commission will deliberate privately and make a final decision at the conclusion of the evidentiary portion of the hearing. The written decision will be issued as promptly as possible. If at any point during the Commission's deliberations it determines that further testimonial or documentary evidence is desirable, it reserves the right to ask the appropriate party to provide such evidence prior to a final decision being made. We will now swear in all the witnesses. Attorney Kennedy and Attorney Nozel, are all the individuals you anticipate presenting testimony in this matter present on this call?
Yes, Chair.
Yes.
Thank you. If there is anyone who is not present or they show up later to testify, it will be up to you to alert me that they've yet to be placed under oath. So at this time, anyone who's going to be testifying today, please raise your right hand. Do you solemnly swear that the testimony you will provide before the Commission at this proceeding to be the truth, the whole truth, and nothing but the truth?
I do.
I do.
I can do the screens.
I do.
Thank you. I will note for the record, all have responded in the affirmative. A proceeding of this nature necessarily requires the consideration of a wide variety of information that takes several forms. In this case, some of the information and documentation may include commercially sensitive information. The discussion of such information may place an entity at a competitive disadvantage if such information were to be publicly discussed. For the Commission to be able to execute its legal obligations effectively and diligently prior to making a final finding, it must be at liberty to fully inquire relative to any of these sensitive matters without compromising the individuals or entities involved. To do otherwise would be, at a minimum, unfair and potentially unlawful. Accordingly, my colleagues and I may elect to exercise the discretion afforded in accordance with 205 CMR 101.01, paragraph 7, to close this proceeding to the public to fully address certain matters related to privacy, proprietary, or sensitive technical information, including but not limited to software, algorithms, and trade secrets, or for other good cause shown. Under this same regulatory section, FanDuel may request that portions of this hearing be closed to the public, as well as any such request will be considered. Any such request must clearly state the matters for which the Commission is being asked to close the proceeding to the public. The closed session will be limited to only those matters raised in the request. Before we begin, it's my understanding that a pre-hearing conference was conducted in this matter on July 15, 2025, with representatives of the licensee, the IEB, and legal counsel, at which procedural and evidentiary issues were discussed. Does anyone have any preliminary issues or objections they would like to raise?
Chair, no objections, Chair. I did want to just follow up on your comments regarding closed session in collaboration with the IEB and with notice to the legal division. We do believe that there will be portions of today's hearing that will necessarily invoke some information regarding the internal policies, procedures, and proprietary and other confidential business information of the company. We'll work to try to alert the Commission when we believe that that will be the case and when it may be appropriate to move for closed session. So I just wanted to give a preview of that, and obviously several of the exhibits also certainly touch on and involve confidential information as well, to the extent that they'll be discussed, including exhibits 2 and then 4 through 10. Again, I just preview that, understand it's our burden to demonstrate to you at the appropriate time, and understand the Commission's obvious approach to this and ensuring as much as possible be put on the public record. Thank you.
Thank you, Counselor, and we will weigh each request. With that, we will begin with opening remarks, starting with FanDuel. I will ask Attorney Nozel on behalf of FanDuel to please proceed with any opening remarks you would like to make.
Thank you, Chair. Presenting our opening today is going to be Corey Fox.
Thanks, Jed, and good morning, Chair Maynard and members of the Commission. I'm Corey Fox, Senior Vice President, Public Policy and Sustainability at FanDuel. I'm pleased to be here and to be part of FanDuel's final licensing hearing. FanDuel is a leading online sports wagering platform operating in 24 jurisdictions across the United States. Joining me today on behalf of FanDuel as qualifiers are Amy Howe, CEO of FanDuel Group, Andrew Giancamilli, Chief Operating Officer of FanDuel Group, David Jennings, Chief Financial Officer of FanDuel Group, Peter Jackson, CEO of Flutter Entertainment, and joining me as witnesses are JJ Aga, Chief Information Security Officer of FanDuel, Jonathan Fishner, Anti-Money Laundering Officer at FanDuel, Ben Roth, Counsel and Director of Regulatory at FanDuel. On behalf of both FanDuel and Flutter, I want to thank the Commission for its time today, as well as for all the work that has been done to review FanDuel as an applicant for licensure in Massachusetts. I want to especially thank Director Monahan, Chief Enforcement Counsel Kramer, Attorney Kennedy, and the members of the Investigations and Enforcement Bureau for all their work in conducting a thorough investigation into the company's suitability for licensure in Massachusetts. We are very pleased with the IAB report and its findings that FanDuel and all of its qualifiers meet the high standards for suitability in Massachusetts. This is particularly noteworthy given the thoroughness of the investigation that was conducted. We were last in front of you in January of 2023 to obtain our temporary license to operate in Massachusetts. Since then, we have operated successfully and responsibly in the Commonwealth. Since commencing operations in March of 2023 through the end of June this year, Massachusetts customers have placed over 148 million wagers, generated $490 million in revenue, and paid over $96 million in taxes to Massachusetts. We are pleased that the IAB report highlights several of the company's strengths, including its corporate governance and commitment to responsible gaming, as well as its financial performance. We look forward to answering any questions that the Commission may have. Thank you.
Thank you, Corey. I should say Mr. Fox. Councilor Nozel, any further?
No, Chair, we can turn it over to the IEB.
Thank you. We will now turn it to Attorney Kennedy to make any opening remarks on behalf of the IEB, and then Attorney Kennedy, you can move straight on into the presentation.
Thank you very much. Good morning, Chair, Commissioners, Daniel Kennedy, Enforcement Counsel for the IEB. With me today are Chief Enforcement Counsel and Assistant Director of the IEB, Kathleen Kramer, and IEB Director, Caitlin Monahan, along with members of the IEB's investigatory team. Thank you for the opportunity to present the IEB's investigation regarding durable suitability of Betfair Interactive US LLC. For today's purposes, in my remarks, I'll be referring to the applicant as either Betfair Interactive, the applicant, or more colloquially, FanDuel. Before we begin the presentation, I'd like to recognize the investigatory team. Starting with the State Police Unit led by First Lieutenant David Collette, that team includes members of GEU, retired GEU troopers working in capacity as contract civilian investigators. Additionally, I'd like to recognize the Financial Investigation Team, and specifically Chief Financial Investigator Monica Chang, for the tremendous amount of work that they've done on this investigation. The Financial Investigation Team was also supported by contract investigators from the firm RSM, who I'd also like to thank for their hard work. Finally, I'd like to recognize CEC Kramer and Director Monahan for their leadership and guidance to the entire team throughout this process. As the Commission is aware, FanDuel has submitted an application for a Category 3 mobile sports wagering operator license pursuant to General Law, Chapter 23N, Section 6B3. The applicant is not tethered to a Category 1 or Category 2 license in the Commonwealth. The IAB conducted a review for preliminary suitability pursuant to 205 CMR 215.01(2)A and B and submitted its report regarding the review to the Commission on January 3rd, 2023. That report has been marked as IEB's Exhibit 3 in your packet. On January 19th, 2023, the Commission voted unanimously at a public meeting to allow FanDuel to request a temporary Category 3 sports wagering license. On February 23, 2023, the Commission's then Executive Director issued a temporary Category 3 sports wagering license to FanDuel. FanDuel received its operations certificate on March 10th, 2023 and launched on that same day. The licensing division rescoped FanDuel's application based on the legislative amendment to General Law 23N, Section 5B and 205 CMR 215.02, identifying the 6 entity and 4 individual qualifiers. On May 8th, 2023, the licensing division determined the application was administratively complete and transmitted the application to the IAB for its full investigation. The IAB conducted an investigation for full suitability, and the findings are detailed in the report marked Exhibit 2 in your packet. The investigation was performed in accordance with 205 CMR 215.011C, and further description of which is found beginning on page 6 of Exhibit 2. As you know, suitability is an ongoing concept, and the IAB's report is intended to assist the Commission in making the determination as to FanDuel's suitability at this time. The factors the Commission shall consider in making determination of suitability are found in General Law 23N, Section 6, 205 CMR 215, and 205 CMR 218. These were previously detailed by counsel and are outlined in Exhibit 2 on pages 6, 7, and 8. As part of the investigation, investigators conducted a review of the applicant company, Betfair Interactive US LLC, including its history, product line, and offerings, as well as overseas operation where applicable. Investigators also conducted an on-site visit of the applicant's New York City office. The applicant was cooperative in the investigation and provided information whenever needed. Investigators had meetings and correspondence with FanDuel, primarily through Legal and Regulatory Affairs Counsel David Ehrman, Senior Vice President of Sustainability and Policy Corey Fox, and outside counsel Nick Jackson. The information and responses provided by FanDuel were sufficient to evaluate each area of the investigation's inquiry. FanDuel, as I said, was fully cooperative and provided information on its own initiative as well as all requests. As previously stated, the 4 individual qualifiers and 6 entity qualifiers were identified in the review. The review conducted by the IAB served as a window into the operations of FanDuel and its parent company, FanDuel Group. In the time that IAB and its agents from RSM were able to review submissions and requests, as well as supplemental documentation. For the purposes of this review, the report and its observations were made primarily from documentation and responses provided. In the report, particularly the financial section, some updates beyond the date of the report, of the initial providing of supplemental documentation is noted as such. After the IAB completed its report, it was submitted to FanDuel for factual accuracy. In this review, FanDuel had an opportunity to examine the report made by the investigators and the results of its investigation, and they provided their own written responses to some of the material, which have been included in the exhibit packet as items 9 and 10. Today's presentation will provide an overview of our investigation and highlight some of those key points. All of the steps were taken in order to assist the Commission in determining if the applicant has satisfied its affirmative obligation to demonstrate their suitability by clear and convincing evidence. In today's presentation, you'll hear first from Kevin Murphy, retired member of the GEU, acting in this matter as a civilian investigator, regarding the method and scope of the investigation undertaken by the GEU, as well as the findings of that portion of the investigation. You'll then hear from Dan Mass and Chris Fitzgerald from RSM, who will similarly discuss the methodology and scope of the investigation undertaken by the team. RSM will present the findings of the financial investigation of the applicant, entities, and the individual qualifiers. And finally, we will conclude with a review of FanDuel's corporate governance. Ultimately, you'll hear that following a thorough investigation, the IAB is recommending that the applicant, the entity qualifiers, and the individual qualifiers have established by clear and convincing evidence their suitability, and the IAB is recommending a finding of this Commission for full suitability of the applicant. With that, I believe we can begin with Kevin Murphy to explain the scope and methodology used by GU during the investigation, as well as the findings of that portion of the investigation.
Thank you. Good morning, Chair and Commissioners, and good morning, representatives from FanDuel. For those who I have not met, my name is Kevin Murphy. I am a civilian investigator assigned to the Massachusetts Gaming Commission Investigation and Enforcement Bureau. Assisting me in my portion of this investigation was State Police Sergeant James Thompson. After an in-depth review of all applications and submissions from Betfair Interactive, doing business as FanDuel Sportsbook, a thorough background investigation was conducted regarding this applicant. The applicant consists of 6 entity qualifiers. They are Betfair Group Limited, FanDuel Group Parent LLC, FanDuel Group Inc., Flutter Entertainment PLC, The Sporting Exchange, and TSC Holdings Limited. as well as 4 individual qualifiers, Ms. Amy Howe, Mr. Peter Jackson, Mr. Andrew Giacomelli, and Mr. David Jennings. As part of this investigation, routine communications were conducted with the applicants, which required the submission of additional information and supplemental documents, all of which were provided in a timely manner. The process by which this investigation was conducted involved extensive research and discovery of any additional information which could be learned about the applicant, associated entities, and the individuals from as many sources available to us. Queries were conducted for any criminal history at the state, local, and even international level. As of the date of this report, the IEB only had authorization to review fingerprint submissions of individual qualifiers who own 10% or more of a corporate applicant. Without access to fingerprint submissions and therefore automated fingerprint identification system known as AFIS, the IEB was unable to run national criminal history checks on individual qualifiers. Investigators utilized criminal record checks through the Department of Criminal Justice Information System, which is state-specific and reliant on biographical data only. The IEB recently obtained authorization to run fingerprints and will seek to do so as soon as practical. Civil litigation databases were queried and reviewed regarding any lawsuits filed against the applicant, entities, or individuals. Particular attention is paid to any suits that contain any accusations of derogatory or fraudulent business practices. In regard to this specific investigation, no litigation was disclosed or discovered that revealed any such accusations or judgments. Educational degrees, professional licensures, and political donations were also verified. Secretary of State and SEC databases were queried regarding any filings reported by the applicant or qualifying entities. Any results obtained were reviewed for any derogatory information, such as UCC filings or liens relating to the applicant or involved entities in this transaction. No such information was discovered. Open source and media outlet checks were conducted and reviewed, including social media. All content that was reviewed revealed no derogatory information regarding any of the involved entities or individuals. Also, as part of these investigations, a sample of other jurisdictions in which the applicants are already conducting gaming-related business were contacted. All responses received from other jurisdictions revealed no derogatory or disqualifying information regarding their existing licensure or suitability. In-person interviews were conducted of Mr. Giacomelli and Mr. Jennings, and remote interviews were conducted of Ms. Howe and Mr. Jackson. The interviews were all electronically recorded and full reports were prepared. Betfair appears to be committed in their responsible gaming strategy through their responsible gaming plan, goals, and policy. In addition to this commitment, they have KYC protocols in place, which requires online Betfair players to undergo identity verification when they deposit funds, enter contests with entry fees, and when funds are withdrawn. Following a detailed review of all relevant factors, including compliance, litigation, open source, and overall integrity, it was determined that no issues or discrepancies were identified. All practices and conditions were found to be in full compliance with the established guidelines, and no areas of concern surfaced. Thank you for your attention, and I'm happy to answer any questions.
Thank you, Mr. Murphy. Questions, commissioners? Questions, Attorney Nozel?
No, Chair, no questions.
All right. Mr. Kennedy, you can proceed.
Thank you, Mr. Murphy. That concludes that portion of the presentation. And at this point, we would be turning to RSM's discussion. I'd like to pause there, however, because I do understand that there may be a request at this point. I can turn it over to Attorney Nozel to explain that request.
Sure. Thanks, Attorney Kennedy. Chair, it's our understanding now the presentation by RSM is going to touch on topics that we believe are appropriate to be discussed in closed session that includes internal policies and procedures of the company, technical information, pertaining to the company's operations, the company's finances, issues around cybersecurity and anti-money laundering program and practices, among other topics. It's our position that that information is appropriate for closed session. We believe that it's consistent with the way the commission has treated other applicants as well, and that has been done effectively and judiciously. We have discussed this again, trying to make this as efficient as possible with the legal team and the IEB in advance to be certainly coordinated, understanding it's our burden to demonstrate that we believe that this portion of the hearing should be closed. Certainly as a fail-safe, to the extent that any topic is covered in the closed session that is not covered by what I've represented to you, we certainly could come back and add anything to the public session, but certainly can't do the opposite. So I'd request that the RSM presentation portion of the hearing be done in closed session. Thank you.
Thank you, Attorney Nozel. I think out of all of these, you articulated very clearly your position. Commissioners, would we like to close this proceeding in accordance to our authority under the reasoning that Attorney Nozel suggested?
Mr. Chairman, that would be fine with me.
All right, I'm getting yeses and thumbs up across the board for the record. Therefore, we will, in fact, close the proceeding, and we'll pull anything back in public that needs to be pulled back in public. All right, we're going to be moved over. Okay, Connor, I think we can take the screen down. All right, I think everyone is back. From the commissioner's standpoint, I'll ask Councilor Kennedy and Attorney Nozel to confirm that everyone's re-entered that needs to re-enter.
Yes, everyone for the IEB is present.
Thank you.
I believe that's the case for the FanDuel team.
All right. So we're re-entering the public portion of this hearing after a robust conversation in private. And with that, I'm going to turn it back over to Councilor Kennedy to continue where he left off.
Thank you, Chair. As I just mentioned in the closed session, the IEB has concluded its presentation and we will be resting on our filings at this point.
All right. Commissioners, any questions? Any questions for you, Jed?
None to the IEB, Chair.
All right. We'll now turn to the presentation by FanDuel. Attorney Nozel, please proceed.
Thank you, Chair. I appreciate the opportunity. Although we didn't discuss this at the beginning of the hearing, I did want to indicate for the record that the company has agreed to stipulate to the report's findings, certainly is in concurrence with the report's recommendation that FanDuel and its qualifiers be found suitable. We do believe that the report certainly meets the standard of clear and convincing evidence of the applicants and the qualifiers' suitability. And where the report has identified a few limited issues that we discussed in the closed session, as indicated in connection with that presentation, FanDuel has provided updated information to the Commission, and that is included as an exhibit, Exhibit 8, that we will also rest on in connection with our presentation. Notably, the company isn't challenging those issues, but rather informing the Commission on how it's working to address them. And I do note they were of not, again, of a level certainly that is very marginal. We do have a team of experts here to answer any additional questions that the Commission has. Both our witnesses, Corey Fox, Mr. Aga, Chief Information Officer, Jonathan Fishner on AML issues, Mr. Roth on anything dealing with regulatory and compliance. We're also supported by a whole bunch of additional folks from FanDuel as well, to the extent that the Commission has questions regarding any other topics of inquiry. And we're happy to take any of those additional questions at this point. But we also are prepared to rest on the evidence that's been presented to the Commission at this juncture. And the only other thing I will say, Chair, is to the extent that there are questions that require us to go back to a closed session, I'll flag that for your consideration at the appropriate time.
Thank you, Counselor. Commissioners? Any questions? All right. Give me 1 second here. I'm assuming, Attorney Nozel, with that, you've rested. You're mutes. You're muted.
I apologize, at least once during the hearing. Yes, assuming there are no additional questions by the Commission, and the IEB has nothing to, well, I guess we haven't presented anybody to be crossed. We would rest, yes.
I will ask just one more time to button everything down. Commissioners, no questions. And then Counselor Kennedy, any questions?
No questions.
All right. We're now going to go into the topic areas as set forth in the hearing notice. We will turn to the specific itemized subject matters from the notice of hearing. With respect to the first bullet from the hearing notice, which states the durable suitability of FanDuel pursuant to 205 CMR 215.011, does any commissioner have any questions for any witnesses present here today, generally with respect to the durable suitability of FanDuel pursuant to 205 CMR 215.011? All right. With respect to the second bullet from the hearing notice, which states the contents of the Investigation Enforcement Bureau's suitability report, does any commissioner have any questions for any witnesses present here today regarding this topic? All right, hearing none. Now that we've heard all the evidence in this matter, before we move to closing remarks, I'll give everyone an opportunity. I'd like to turn to my fellow commissioners one more time and make sure there are no further topic areas that anyone would like to explore, and that all of our questions have been answered. I'm getting yeses. We'll now move to closing remarks. Each of the parties will be afforded an opportunity to make a statement summing up their position, though they need not do so. Attorney Nozel, would you like to proceed?
Thank you, Chair. Again, I'm going to turn it over to Mr. Fox.
Just wanted to thank the commission as well as the IAB again for the thorough work here, and we're here to answer any questions if they come up in the future. Thank you.
Thank you, Mr. Fox. Thank you, Attorney Nozel. Counselor Kennedy, any final statements?
Thank you, Chair. Based on the IAB's investigation, the IAB submits that the applicant, the entity qualifiers, and the individual qualifiers have established suitability by clear and convincing evidence based on the criteria set forth in Massachusetts sports wagering laws and regulations. The IAB is recommending a positive determination of suitability for the applicant, the entity qualifiers, and the individual qualifiers under the one condition that the individual qualifiers update fingerprints where needed. With that, I'd just like to thank the Commission, the IAB's investigatory team, and FanDuel for their cooperation during this process. Thank you.
Thank you, Counselor. Unless there are any further matters that the IAB, FanDuel, or my fellow commissioners would like to address, we will now conclude this portion of the proceeding. Does anyone have anything further? No from Counselor Kennedy, no from Counselor Nozel. The commission will now deliberate about the matter in private, and we are adjourned. Everyone enjoy your day.
Thank you.
Thank you.
And commissioners will move right into deliberation.